I'm going to be very honest with everybody. I don't plan on following this Killebrew agreement. She's an 18-year-old who literally kicked and beat a 14-year-old in a fetal position on the ground and then had the gall to post another video of it on TikTok. This is not a one-time mistake. As I sit here today with the information I have, I cannot in good conscience let this just get swept under. Ms. Jones, have you heard what the attorneys have said the resolution in this case is?
Yes.
And is that how you wish to resolve it?
Yes.
Will you please raise your right hand? Do you solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Ms. Jones, it's my understanding that the agreement today is that you will plead no contest to assault and/or assault and battery. That is a 93-day misdemeanor and/or a fine of $500, and consecutive sentencing may be imposed if the offense happened in the place of confinement. Now, along with that, there's what's called a Killebrew agreement. And what that is the prosecution and your attorney and you have reached an agreement that you'll be placed on a delay of sentence. And if you're successful with that delay of sentence, the case would be dismissed. Do you understand that?
Yes.
Now, if I decide that I do not want to go along with that agreement, you have the option to withdraw your plea. Do you understand that?
Yes.
Additionally, this is going to be a no contest plea due to potential civil liability. What that means is that the alleged victim in this case could potentially sue you for any damages in which she's incurred. A no contest plea allows me to read a document, looks like it's going to be a police report, and use that police report to determine whether or not there's a factual basis to accept the plea and to use that for sentencing purposes. Do you understand that? Additionally, a no contest plea cannot be used against you. So if you are going to plead guilty and this person sued you, that guilty plea could be used against you. The no contest plea means that it's not. Essentially, you're accepting responsibility without saying that you did it. Do you understand that?
Yeah.
And is that how you wish to proceed?
Yes.
Back on March 31st of this year, were you on probation or parole?
No.
Were you on bond in any other file?
No.
Then Ms. Jones, to the offense that on or about March 31st, 2025, here in the city of Cadillac of Wexford County, how do you plead to committing the offense of assault and/or assault and battery?
No contest.
As does the court. I find the plea is knowing, voluntary, and accurate. As such, Ms. Jones, I find you guilty of assault and/or assault and battery. In particular, on March 31st, 2025, there is a video that shows Ms. Jones hitting, kicking, kneeing as the victim is lying in a fetal position by what's commonly referred to as the old dam. The court can take judicial notice that is located here in the city of Cadillac and is between Haynes Street and River or Wright Street. The victim is a 14-year-old middle schooler. The victim reported that she had no injuries. It is alleged in the police report that Ms. Jones posted another video on TikTok captioned round 2. And this appeared to be all over some things that were said about another's deceased mother. As such, I find that the elements are made out for an assault and battery, and that this would have been an unwanted, forceful, violent touching. Mr. Carnes, are we able to sentence today?
Yes, Your Honor.
Mr. Hartel, any allocution?
Yes, thank you, Your Honor. Anytime it's no contest, especially for civil liability, I'm cautious to overly allocute for obvious reasons. But what I will say is my client has, to my knowledge, done well on bond. She stayed in constant contact with the defender's office, been very cooperative. She does have strong ties to the community. I don't doubt she'll do well on probation. She's highly motivated to do well and receive the benefit of the delay. I, in these situations, always advise my clients if they don't do well, there is the risk of jail later, the loss of the delay, the public adult record. She's a relatively young adult. She wants to be able to pursue various careers and ambitions. At the moment, she's working at Qdoba. She's aware she owes some money on some older files, but she is going to, I believe, do a wage assignment, if I understand that correctly. She also has some friends with her in the courtroom who've been supportive throughout these procedures, and I don't doubt will continue to be supportive of her as well. I ask the court to uphold the killer. Thank you.
Hans?
Thank you, Your Honor. This is a disturbing incident involving a defendant and a 14-year-old. Clearly shows some lack of judgment, lack of maturity. However, the defendant does not have any prior convictions. I think ultimately this is a fair resolution of the file. I'd ask the court to place Ms. Jones on a delay of sentence of up to 8
Mr. Carnes, I know the CCH is relatively blank because she's just now 18, but there's some juvenile history, is there not?
Your Honor, I don't show that on me, and I am familiar with Ms. Jones on some other things, but not where she was the defendant. If the court has.
Well, I'm just trying to remember. I remember, seems like climbing on top of the school for the 4th of July. Were there charges on that?
She reached 18. That was resolved with the civil infraction. I'm just going purely off memory, Your Honor.
I'm going to be very honest with everybody. I don't plan on following this Killebrew agreement. This case centers around an 18-year-old woman named Miss Jones, who was involved in a serious assault incident involving a 14-year-old girl. According to the information presented in court, the younger victim was attacked while on the ground in a defensive position. The situation became even more controversial because the incident was reportedly recorded and later connected to social media activity where videos and captions appeared to suggest that the event was being treated casually rather than with regret. The legal process started with an agreement between both attorneys. Defense and prosecution had reached what is known as a delayed sentence agreement. Under this type of arrangement, the defendant would plead no contest, complete certain conditions successfully, stay out of trouble, and potentially have the case dismissed in the future. Essentially, if everything went smoothly, the offense would not remain on the defendant's permanent record. During the hearing, the judge carefully explained the legal details to Ms. Jones. He made sure she understood what a no contest plea meant and explained how it differed from a guilty plea. A no contest plea allows a defendant to accept the legal consequences of a charge without directly admitting responsibility. This can sometimes be important in situations where civil lawsuits could happen later. After reviewing the details of the incident, the judge described what was shown in reports and evidence. The court discussed allegations that the victim, a middle school student, had been struck while on the ground and unable to properly defend herself. The judge also mentioned social media content allegedly connected to the event, including a post that appeared to treat the incident as something worth celebrating rather than regretting. The defense attorney argued that Ms. Jones had been cooperative throughout the process. According to the attorney, she had followed bond conditions, stayed in contact with legal representatives, and maintained ties to her community. The defense also explained that she was young, had future goals, and wanted the opportunity to move forward in life without carrying a permanent criminal record. The argument focused on giving her a chance to prove that she could learn from her mistakes and improve her future. The prosecutor also acknowledged that the situation was disturbing, but pointed out that Ms. Jones did not have previous adult convictions. The prosecution believed the agreement was fair and supported placing her into the delayed sentence program. However, the judge appeared to have concerns that went beyond what was written on paper. He questioned whether this event was truly an isolated incident or part of a larger pattern of behavior. While discussing the case, he referenced memories of previous situations and other legal matters connected to the defendant. Although some of these matters may not have resulted in criminal convictions, the judge suggested that he had concerns about repeated involvement in troubling situations. At that point, the judge made it clear that he was not comfortable immediately approving the agreement that both attorneys had worked out. He explained that programs designed to dismiss charges are often intended for individuals who made a single mistake and deserve a second chance. In his view, information before him raised questions about whether this case fit that category. Instead of approving the agreement, the judge decided to delay the final decision and move the case to a full sentencing hearing. He gave both sides an opportunity to submit additional arguments and evidence explaining why their position should be accepted. Rather than immediately closing the case, He wanted more time to consider whether allowing the offense to disappear from the record would truly serve justice. The case created debate because it raised difficult questions. Should young people who make serious mistakes be given another opportunity to rebuild their future? Or should actions that involve violence and apparent public celebration of that behavior carry stronger consequences? The judge ultimately stated that based on the information available at that moment, he could not allow the matter to simply disappear without further consideration. His decision showed that even when attorneys agree on a resolution, judges still have the authority and responsibility to determine whether the outcome truly reflects fairness and accountability. The case now moves forward with additional review, where both sides will continue presenting arguments before a final decision is reached.